We're ready to start again. What I thought we would do, because again we're under some tight time constraints, is take a few questions to Norm and then move on to our next speaker, Harold Rolph. Any questions for Norm on his, I think, excellent analysis of the civil lawsuit context?
You've been a terrific audience. Well, that's the point. I'm not saying anything except these are procedural problems which are being thrown up by the courts, and I don't know whether this line of authority is going to blossom or whether it's going to be cut off at some point. I guess you've got to analyze the type of case you have, the type of clients you have, what they want to achieve through the process, what their objectives are, and one approach is to file the human rights complaint, save your limitation period, and take the procedural risk. And that's something you have to discuss with your client. You've got to say, hey, if we do it this way, there's a risk that the employer will bring a motion to stay our civil proceeding. Maybe they won't. Maybe they're not as sharp as I am. But if they do, that's a risk that we take. But that's the price we may have to pay to keep both avenues wide open ultimately.
Just I want to make a comment. The other thing on the limitation on the civil remedy, of course, is that you can't get reinstated. And if reinstatement is the issue, then you've clearly got to go the human rights route.
That's a very important point because John's quite right. The only way you're going to get reinstatement, and that's why I say consider carefully your client's objectives. If they want their job back one way or another, whether it's alone or in conjunction with the civil action, you've got to adopt the human rights approach.
Okay, go ahead. Just let me repeat the question. I think the question or the comment was that there is a risk that the creative actions will be stayed in any events, I guess, on a point of law. And I will let Norm speak to that. I think he's indicated there are some ways around that by creatively pleading the appropriate causes.
I think it's a good point. I think the 2 points that I would like to make are that the way in which you plead it, as John says, is critical. You want to make it look as little like a human rights complaint as you possibly can, so that it's not easy for opposing counsel to say this is really a human rights complaint, they're in the wrong forum. And the second thing is, it's my view that judges are going to, given the profile of sexual harassment allegations, are going to be less likely to stay that type of action without the they're already expressing their reluctance to do it when there's an existing human rights complaint. I think they're going to be even more reluctant to do it in the absence of that human rights complaint.
Okay, thanks, Norm. I think we're going to, again, for time, move on. Now, after hearing all these landmines that are facing employers out there, we thought that it was an appropriate time in the program to turn to someone who had experience in guiding employers through the various landmines. And I know from some personal experience I've had dealing with Harold Rolph of McMillan Bench that he's a person who can direct employers through difficult landmines. And what Harold's going to talk to us about is how do you deal with a complaint when it arises from an employer's perspective, and I think touch on the very practical concerns arising out of the more substantive legal issues we've heard discussed to date. Turn it over to Harold.
Thank you, John. Before I deal with what you do when you get the complaint, I want to say something about what you might do before you get the complaint to put yourself in the best possible position. And I may well be repeating some of what was said earlier this morning, by Susan Bisset and perhaps others. I note in the program, and I've looked briefly at her material, Susan Bisset talked about sexual harassment policies. In terms of potential defenses that may be available to an employer, I am in favor of a well-drafted sexual harassment policy, particularly one that has a good complaint procedure that allows these issues to be raised and disposed of internally. Why do I like sexual harassment policies? First, they may allow an employer to find out early about a situation, about a potential complaint, and resolve it before outsiders become involved. And by outsiders, I mean lawyers and the Ontario Human Rights Commission. It also may be of use to the employer in what I'm going to call somewhat liberally, given that we're dealing with an administrative remedy, what I characterize as a due diligence defense. And I'll speak to this later in my remarks, but there is some scope, clearly under the Canadian Human Rights Act, and I think also under the Ontario Human Rights Code, for an employer to try and argue, I wasn't aware what was going on. I couldn't reasonably be aware of what was going on. I had procedures in place whereby employees who were suffering these kinds of problems could come forward and obtain relief. There is a trend in discrimination cases under the code to be quite expansive in terms of remedy and compensation. At one point, some of the human rights boards were fixing compensation on the basis of what was reasonable notice at common law. Recently, there's been a departure from that, and there's support now for the proposition that the employee should be compensated for all wages until the effects of the discrimination are gone. That may mean compensation until the employee finds a new job, which can be an expensive proposition. The existence of a internal policy which may allow an employee to resolve these issues early may be helpful to the employer, in that the issues, if they're taken care of, you don't have to worry about compensation claims. It may also come in handy for you if, in fact, you are caught in litigation and there is a finding that you were responsible for discrimination. You may be able to argue that if there was a policy that the employee didn't use and could have, the policy that the employee didn't use and could have used to retain her job, that may be a mitigation argument on the compensation. Again, it's just one point that I think argues in favor of having one. And the other aspect where it will come in, I think, useful, is that when you get a human rights complaint, you are in effect looking probably at two legal problems, two areas of liability, because you're very quickly going to be faced with the problem, what's my liability vis-a-vis the complainant? And then you have to turn around and look at who the alleged harasser or harassers were in many cases, and you're then going to have to ask yourself, what's my liability vis-a-vis them? And in some situations, you are going, as an employer, are going to have to terminate or discipline the harassers. The existence of a policy will strengthen your position to be able to argue that you have cause for terminating someone who's engaged in sexual harassment. Now, Norman Grossman has previously referred to one or two cases where cause at common law has been based on sexual harassment. I don't think you need a policy to establish cause where you have blatant sexual harassment, where there are forced demands for sexual favors and things of that nature. However, the courts are perhaps more sympathetic to what I might characterize as the milder form of sexual harassment, where you are dealing with banter and shop talk with some sexual overtones. There may be some concern on the part of the courts that you had individuals engaging in this who were just not sensitive to how contemporary mores have changed about what's acceptable and unacceptable in terms of comments and comments of somewhat of a sexual nature, flirting. The existence of a policy that spells out in some detail the full ranges of sexual harassment is going to make it very difficult for someone who engages in that to try and say, well, I really didn't understand that this was no longer acceptable. So the policy helps you there too. The other comment that I make is that the existence of a policy is going to help you in making what will, if you have to resist a complaint, is going to be your likely defense, assuming that there's some merit to it, which is, you know, we've made reasonable attempts to try and deal with the issue. The other thing to say about the policy is to make sure that it's well communicated, both to employees who don't exercise managerial functions and to employees who do, both from the perspective of their own conduct and then also from the perspective that the supervisors are aware of what sexual harassment is or may be and are sensitive that if they spot signs, they do something about it and not let it fester and build. In terms of the legal framework of the liability of an employer, the leading cases are some decisions of the Supreme Court of Canada. I refer to one, Worth and Canada, which was the Federal Treasury Board. The Supreme Court of Canada articulated a standard whereby an employer was effectively responsible for anything that happened in its workplace. And they said, we're not really concerned about whether or not this discrimination was intended by anyone. What we're concerned about is the fact and effect of discrimination, and an employer is under a duty to avoid that effect. And we will apply remedies against an employer where it occurs, even though the employer may not have known about it and may not have been able to prevent it. In the federal sphere, there was, following that decision, if my chronology is right, they made an amendment to the Canadian Human Rights Act, which in effect creates a form of due diligence defense. The section is section 65 of the Canadian Human Rights Act, which in effect creates a due diligence defense for an employer. Basically, that defense breaks down to the employer showing a lack of intent. The employer didn't consent or condone the discriminatory act. The employer took all due diligence to prevent discrimination. That requires an employer to be proactive and make sexual harassment policies and educate staff. The employer took all due diligence subsequent to the discriminatory act to mitigate or avoid its effect. And that, in effect, means that the employer does a thorough and prompt investigation, and the employer works hard to communicate with the complainant to assure her or him that the matter is being looked after and that his or her interest will be protected. The Ontario Code does not have that kind of explicit due diligence defense. It does, however, suggest that an employer will not be liable for all acts that are committed in its workplace. The relevant section is section 45(1), which I reproduced on page 2 of my paper. Section 45(1) in effect creates vicarious liability on the part of an employer for any act done by an officer, official, employee, or agent. It, however, excludes that vicarious liability in respect of certain provisions, which include Section 7 of the Code and others, where you will normally find the statutory basis for a sexual harassment complaint. Section 45(1) and the implication of limiting the scope of vicarious liability will give an employer some protection where another non-managerial employee has engaged in the action, provided, in the case of the non-managerial, the employer didn't know what was going on and couldn't reasonably know about it. In the case of someone who is exercising managerial functions, you have the concern that that person will be either characterized as a directing mind of the corporation or some very elaborate theories of organic corporate liability articulated. And I think we heard someone from the Commission say earlier this morning that if someone's a supervisor, they regard the employer as being vicariously liable. Practically speaking, all I think an employer in Ontario can do is educate its employees, do what it can to have procedures in place to catch these issues, and if you get the complaint, and if it is in fact a complaint with merit, you will then have to make a judgment about whether or not you've got a defense based on the fact that you didn't know what was going on and couldn't reasonably be expected to know what's going on. That becomes very difficult where the person who engaged in it is exercising any kind of managerial function. Now, I think I can say in an unqualified way that a sexual harassment complaint is bad news for an employer and is potentially what I would characterize a lose-lose situation. What do I mean about that? As soon as you get the complaint, you've got to be concerned about your legal liability to the victim or complainant. You've also got to start thinking about what your liability is going to be vis-a-vis the person who allegedly engaged in the harassment, because you're probably, if there's substance to it, going to have to take disciplinary action and discharge. Looking more prospectively, when you get a complaint, you've got to think about what's my liability as employer to my other employees, because if the person who engaged in the harassment, or if it's a more widespread type of thing where a number of employees are saying things and you've got what they characterize as a poison environment, you've got to start thinking, what kind of prospective liability am I going to have if this continues vis-a-vis other people in my workplace? This double potential legal exposure aspect to these cases, in my view, makes them some of the most difficult ones to deal with. And to put it on a very simple basis, in terms of a complaint and defending against that complaint, there is a high probability that your star witness is going to be the alleged harasser. That's the person who's going to be able to rebut the claims. That means that you very quickly have to make a judgment about whether or not the alleged harasser is telling you the truth, because in terms of your defense, it's going to be based on the quality of his or her evidence in large part. On the other side of the coin, if you determine early on that the complaint has substance, has merit, that there is sexual harassment, you are then going to be thinking about your rights as an employer vis-a-vis the person who engaged in that harassment. If you take legal action and find yourself in litigation, which can come in the context of a wrongful dismissal action, a grievance that goes to arbitration under a collective agreement, or if the person were employed by a bank or other institution subject to the exclusive jurisdiction of the federal government under the Canada Labour Code, a Section 240 adjudication procedure, the complainant, the person who blew the whistle, may well be your star witness in justifying what you've done vis-a-vis the harasser. The only problem is that you may be in litigation with her too. So you're looking to someone who's at the opposite side of a legal action as being a key witness potentially in another legal action. So this creates considerable complexity and a requirement for some well-informed strategic decisions that you make very early on in the piece. How does sexual harassment complaint arise? First way it arises is the employee comes forward internally and tells you that he or she has been harassed. From an employer standpoint, I think that's the best scenario, because you've got the best option of handling it internally. Second, you get a telephone call or an actual complaint from the Human Rights Commission, and you then know you're into that mechanism. Third, you get a letter from a lawyer or a statement of claim, and you've heard Norman Grossman talk about how sexual harassment may be woven into a civil action. I'm not sure, he certainly mentioned the constructive dismissal theory. The other one that I saw that seemed to be quite popular with a particular law firm a couple of years ago was they would sue the employer for wrongful dismissal, and I've seen it in the context of constructive. They would also name an individual defendant as well, preferably someone as senior as possible, like the president of the corporation, and then allege that that person had sexually harassed, and as a result of the refusal of his advances, he had then caused the corporation to terminate or materially alter the terms and conditions of the female employee. So they put forward an inducing breach of contract theory against the senior executive. The point I would make about those are, it may be an effective technique if in fact there is real substance to the sexual harassment complaint, because if a senior person is accused of that and there's real substance there, in fact the employer may want to settle the case very quickly. But I'll tell you, if it is not a lot of substance and is a more questionable claim, I would caution you to think twice about trying it, because I'll tell you, you make those kinds of allegations and you then cause that executive to try and justify his or her position And instead of it simply being an economic issue about what it costs to get rid of a particular employee, which will tend to be settled relatively quickly, if it then becomes an issue about the propriety of a senior executive's conduct, you may find you got a real fight on your hands. The other way I have seen the sexual harassment complaint be raised is you get a claim under the Employment Standards Act for termination or severance pay. You thought the employee quit. Now the allegation is that there was a constructive dismissal. The employee is saying, well, I had to leave because of what they were doing, and since I had to leave under the Employment Standards Act, I have minimum entitlements to termination and severance pay. And I've dealt with them in that context. You may, and these are very difficult to deal with, receive a visit or telephone call from the police. And you will find that the police are investigating a form of sexual assault that may have taken place in your workplace, or one of your employees is involved. Those are very difficult situations because the criminal proceeding is ongoing, but in my view, once you get notice that there has been sexual harassment of an employee in your workplace, it's my view that under the Human Rights Code or the Canadian Human Rights Act, you have an obligation to investigate that matter, and you have an obligation that if there is evidence that somebody is engaging in sexual harassment in your workplace, I think you as an employer have an obligation to protect your other employees from that person. And it can be very difficult if you become aware of this in the context of an ongoing criminal investigation, and it happens. You may also become aware of the sexual harassment allegations in the course of an investigation by a professional disciplinary body. Complaint is made about a company doctor to the College of Physicians. They will initiate a disciplinary investigation. I was recently made aware of a situation where one of our clients had engaged a temporary nurse during a maternity leave or something of that nature. Several months after that person had left, an investigator from the College of Nurses called them saying, we've had some complaints of improper sexual type physical conduct on the part of this nurse. We have the name of one of your employees. We also want to know what other of your employees were seen by this particular individual, because we want to see if it went further. So you quickly appreciate that the context in which this sexual harassment complaint may come to your attention as an employer are quite broad. When you get the complaint in whatever form, what do? In my view, what you have to do is conduct a thorough investigation as quickly as possible. You have to try and be discreet because you have to be very concerned about the damage that can be done to the reputation of the people who've made the allegation and the people who are on the receiving end. But it is important to find out as best you can what has gone on. If you can, you should try and interview the complainant so that you have his or her allegations and evidence in the broadest possible form. You should interview co-workers, supervisors, anyone who might have knowledge. It's quite common in some of these situations that if the sexual harasser may have harassed a number of women, you should try and find out as quickly as possible whether other employees, female employees, have been subject to similar behavior. There's frequently, in my experience, discussion amongst female workers about a particular incident before one of them will take the step. Generally, in my experience, has been female workers are very reluctant to make these kinds of complaints. Generally, they engage in a lot of soul searching before they do, Often that soul searching means that they've discussed it with others and found that others have had similar type experiences, and given that, that's what's the impetus to go, for them to go the one step further. You as an employer should try and find out. In the context of human rights complaints under the code, notwithstanding the strictures that criminal and civil courts place on the use of similar fact evidence, the Ontario Human Rights Commission likes similar fact evidence. In my experience, always looks for it, and in my experience, the boards of inquiry under the code are pretty flexible in letting it in. So you better find out about that. If there is any similar fact evidence, find out about it quick so that you know what you're dealing with. And in that context, if you can't get any names of anyone else who may be involved, it may be useful to look at things like, in the area where the alleged harasser was working, did we have a lot of women there seeking transfers, quitting? Because if you see evidence of that, that may give you a means to pursue just why they wanted to transfer, why they left, which may give you a better view as to the dimension of the problem you've got. You must confront the alleged harasser and advise him of what the substance of the allegations are, and get his position. It's a question of judgment when you do that, whether you do it immediately upon receiving the complaint or whether you do it after you've conducted your own internal investigation first. The concern obviously is that that person is in a position of authority. He or she may be in a position to cover his or her tracks, intimidate other witnesses. You have to be careful up front so that when you do confront him, you're in the best position to evaluate the quality and the credibility of the responses that you get. If you appear to be getting into some type of litigious proceeding, I think you've got to get, after you've made your initial assessment of what's going on, you should try and get written statements from the witnesses upon whom you're going to rely. These things can take a long time to come to a hearing or trial. You want to have something in your file that shows why you did what you did. You may want to consider whether or not you can set up a claim of privilege for those statements. Finally, if in investigating a complaint you conclude that it's without substance, my advice is that you prepare a fairly detailed report summarizing what you discovered and justifying or summarizing the reasons why you felt it to be without merit and why it didn't go any further. The reason I say that is you may get a subsequent complaint down the line. This earlier complaint that you were aware of, that you didn't do anything about, may be raised. You as an employer want to probably be in a position to explain any inaction with respect to an earlier complaint of a similar nature. Once you have done your internal investigation, you have to decide upon a course of action. And really, that's going to come down to, if you determine that the complaint is unfounded without merit, that means you're going to have to resist, which means preparing a respondent's questionnaire under the Human Rights Code or preparing the statement of defense. If, on the other hand, the complaint has merit or appears to have merit or considerable substance, then I think you must fairly quickly decide what you can do to rectify the damage done to the plaintiff or complainant. In other words, you have to consider settling very quickly, because you're going to want to try and minimize your financial liability. And you are also going to want to make sure you are protecting other employees who can be exposed to the same thing. The best scenario for you, where you find that there is substance to a complaint, is that the female employee is still in your employ, because you're in a much better position to take steps that will allow her to continue her job, and she's being protected, and you don't have the same kind of financial liability. If she's already gone, then you're going to have to ask yourself, what is a reasonable financial settlement? You may want to consider reinstatement. My experience, however, is in the non-union situation, reinstatement is rare. You have to think, if you're entering into a settlement, how you're going to do it. If there's no actual human rights complaint, you may well enter into the situation of minutes of settlement, a release, a full and final release, non-disclosure clause, and where you have a sexual harassment case, it is customary to get an undertaking for the complainant not to file a human rights complaint. The individuals from the Human Rights Commission told you something about how those releases get treated. I think you have to appreciate that a release is not a guarantee against a subsequent human rights complaint. The Human Rights Commission does reserve the right to review their adequacy, and they will ask themselves the question whether or not this was a reasonable settlement, and will we sanction what is in effect or could be argued to be a contracting under the Act. What I will often do where I'm worried about a subsequent human rights complaint, I may make it explicit in the settlement documents that if they subsequently file a human rights complaint or breach the undertaking not to initiate any further proceedings, that in addition to any other damages to which the employer is liable, the employer is entitled to the money that it paid to settle back. I take the view that that may be a substantial disincentive to someone reneging on a deal, but there is an element of uncertainty, and you have to explain to your client that it's there. If the Human Rights Commission is involved, you are probably going to be forced into a situation where the Human Rights Commission approves the settlement under Section 43. The problem with a human rights settlement in which the Commission participates, clearly, if they agree to the settlement, you don't have to worry about the matter being opened up again by the Commission. They may, however, be looking for something beyond the simple compensation of the female or male victim. They may be looking for more public type remedies, educational courses, seminars, programs. Of more concern, typically, is the Human Rights Commission has a policy that's usually referred to as the no-gag order. In other words, the Commission will not agree, as a term of a settlement, not to publicize the settlement. I have had situations where a settlement is arrived at, and all of a sudden you find out the Human Rights Commission is issuing a press release. Typically, for some employers, the reason they want to settle is to avoid the publicity. Well, if the Commission's involved, you have to tell your client there's no guarantee that the Commission will not subsequently publicize that settlement. Now, you can sometimes get unenforceable assurances from the human rights officers that it's not going to happen. One technique that I have tried on occasion is to get the complainant to, as part of the settlement, make a request to the Commission that the matter not be publicized. The Commission will not publicize the name of a complainant without the complainant's consent, and will often respect a complainant's request that the matter be kept quiet more than they will an employer. So that's one technique I've tried. With respect to the other side of the coin, where you've determined you've got a complaint, that it has substance, you then have to deal with if there is a specific individual, the harasser. As I said earlier, if it's significant sexual harassment, that's likely going to constitute cause at common law. So you can terminate without compensation. You may, however, when you are resolving the complaint with the female employee and you recognize you're heading into litigation with the male employee, you may want to, as a term of your settlement with the female employee, get a specific undertaking from her to cooperate with you in the litigation against the male. One other point that I also think you should bear in mind in the context of your actions vis-a-vis the harasser. Typically, employers will want to tell female employees who come forward, we will keep this confidential. You don't have to worry about it, nothing's going to get out. Well, if you get into litigation with the harasser, it's not going to be kept confidential. These female employees are your witnesses. So I think it's very important to explain to them that while the company will do its best to keep it confidential, to be discreet, there is the risk that if there is litigation, that the matter will come to light and that they may be required to testify. My experience has been, and I've had experience, where an employee has been fired for sexual harassment and we've gone to trial, that if that is explained to the female, and usually the sexual harassment cases are female alleging against male, that if you explain the process to them and you explain it up front, they will be cooperative with you and will understand. But it's very important that they understand what may be happening or can happen early on, because if it's sprung on them after they've been told you don't have to worry about it, it'll be kept confidential, their natural reaction will be, I don't want to be involved, I didn't think this was going to happen, and all of a sudden they won't be very good witnesses. You may even want to go as far as having them meet with the company's lawyer early on in the piece so that he or she can explain what's likely to happen. If the employee is covered by a collective agreement, and now I'm referring to the employee, the harasser, and you terminate or discipline, you've got to be prepared for a grievance that will go to arbitration. Arbitrators may be a little more sympathetic to disciplined or discharged employees in sexual harassment cases than the courts. So you may want to take a look at the arbitral jurisprudence quite carefully in determining what your response is. Also, you've got to be aware of the following tactical concern where you are looking at a grievance by an employee who's been terminated for sexual harassment. The union that represents the harasser may also represent the victim. I am aware of situations where after the male worker is terminated, the union then goes to the female victim and says, well, look, he now understands what he did was wrong. Will you accept his apology? Would you be prepared to go to arbitration and tell the arbitrator, while you were very upset at the time, you're now taking a more balanced view of it, and in fact, if he gets his knuckles rapped, you'll feel able to work with them in the workplace. So what that means is between the time you terminate it and the time you get to arbitration, because of the intervention of the trade union, your female victim, who again is your star witness in the arbitration, may not be as forceful in her evidence as she might have been earlier in the piece. Again, I think it's important in those situations to get a signed statement from the female employee so that you won't be left in the situation where the evidence that's called at the arbitration is substantially different than what you understood it was at the time you made your decisions. And also, you should try and be as supportive and helpful to those female workers and encourage them to come forward if they start to experience a feeling of pressure with respect to the stance that they've taken. Finally, and I'll just say it briefly because Norm Grossman said it before, you've got to be very careful about going off half-cocked in these situations, because if you move precipitously without the right kinds of facts against the harasser, you are then looking at a substantial court judgment where, in addition to reasonable notice, you may be looking at punitives, damages for mental distress. And my own view is that if you fire an employee in circumstances where you have gone off on a bit of a reflexive response to some half-baked allegations, that even on assessing reasonable notice, the courts are going to hit you pretty hard. Accordingly, I would simply summarize by saying these sexual harassment complaints are very interesting cases. They must be taken very seriously, and they must be investigated quickly, because you must make strategic decisions about how you're going to handle them at a very early stage in the proceeding.
Thank you, Harold. That was very instructive. I'm afraid because of time constraints, we're going to have to bypass questions. I, again, apologize for that. I'm going to suggest that we move to the last item on the program, which is managing and dealing with sexual harassment in the law profession and the law firm. And I'm going to ask my old classmate from Osgood, Denise Bellamy, to come up, who's going to speak from the Law Society's perspective as a bencher. And I'm going to take my lawyer's hat off a bit and put my manager's hat on and talk to you about what we've done at Gassels, Brock and Blackwell from a management perspective to deal with this. What I thought we would do is we'd go for a half an hour to 1:15, if that's okay, and then we'll just call it a day at that time. Okay. On my right, as I noted, is Denise Bellamy. Denise is a classmate of mine from the class of '78 of Osgood, and has been a Crown and is now Director of Legal Services for the Ministry of Correctional Services for Ontario. Denise is also a second-term bencher, and we thought it would be interesting to get Denise's thoughts and perspective with respect to the Law Society's response, including the addition of a specific rule to the Rules of Professional Conduct relating to sexual harassment. Denise, you take it away, and then I'll follow.
Thanks, John. Well, I'm assuming that everybody here is as hungry as I am, and I can see from the smiling faces that that is probably the case. So I'll try to be faster rather than slower and tell you that a lot of the stuff is in here in any event. And if you walk out on me, I won't take it personally. I'll assume you really were so hungry that you just had to leave. I should just tell you a little bit about the history of how the Law Society finally ended up adopting a policy on sexual harassment. Many of you will know that the transitions report came out in May of 1991, and this looked at the transitions of lawyers in Ontario who were called to the bar between 1975 and 1990. During the course of the work of the committee that was looking at this, we started hearing more and more people talking about sexual harassment as being a particular problem in law firms. And so while the transitions report was going on, the Women in the Legal Profession Standing Committee decided to at the same time, start looking at sexual harassment. And at the beginning, we didn't really know what we were going to come up with. At the same time as we were thinking of that, the Law Society itself decided that it wanted to develop a sexual harassment policy for the Law Society of Upper Canada itself. So we amalgamated these two ideas and thought, well, we could make up a policy for law firms and at the same time make something up for the Law Society itself. It took us about 18 months. Now maybe that's because as benchers we're really volunteers and we only meet once a month and we don't get anything done as effectively as you would if you were working in a committee. But it did take us 18 months. We had close to 15 drafts before we came to the final document that you have here before you. We also engaged in 2 separate consultations, the early one to kind of get a focus for ourselves, and the second one, once we had a pretty close to final draft, we sent it to a number of legal experts who have already spoken to you today, actually, to find out what they thought of it. We sent it to the Human Rights Commission to find out whether we were way off base. We had 2 people who have written books on harassment, Judith Keene, Human Rights in Canada, and Professor Arjun Agarwal, Sexual Harassment in the Workplace, who looked at it. We were satisfied after having received their comments that what we have developed for the law firms in Ontario is essentially a pretty darn good policy. We didn't do everything that the Human Rights Commission wanted us to do because we also felt very strongly that as employers, law firms have certain things that they have that they should be doing, and you've been hearing, I've been sitting up there and hearing about it for the last hour or 2. We had also sent out 2 earlier documents which are also included in this material in March of 1991. I guess it appeared in the buff pages of the Ontario reports, and it was listed as Sexual Harassment in the Workplace, a Review of the Law of Canada. At that time, we knew we were coming close to developing a policy, but we knew it was going to be some time. So we put together all the law in Canada up to about February or March of 1991, and that is in your material here. So you don't have to go looking for the buff pages and the ORs for it. And then in August of 1991, a few months later, we sent another thing to the entire profession this time, which was called The Problem of Sexual Harassment in the Workplace, Steps That Can Be Taken by Lawyers as Employers. And we did that because some people felt that some law firms were feeling that this really wasn't a problem in a law firm. And the feedback we were getting from some of them was that they were not taking this as seriously as the Law Society felt it should be taken. So these 2 were sent out to alert the profession that they did have a responsibility as employers and that we were going to be coming up with a model policy that could be used by them. Now, I should tell you, just anecdotally, when we first sent this out, we started getting calls from law firms about, maybe 1 or 2 a week or so, asking if we had got the policy yet. And then the Clarence Thomas confirmation hearings hit the airwaves, and instead of the 1 to 2 per week, we were suddenly getting 4 to 5 a day, every day, for weeks. And at that point, we figured we better accelerate this because obviously there was now a real demand for this. So what we tried to put together was a generic personnel policy, a workplace personnel policy that could be used primarily by firms with at least 10, maybe more people, but could be adapted for the firm itself. The Law Society has not taken the position that law firms have to take the model policy that we developed. We just knew from talking to a lot of the smaller firms, particularly with the county and district law presidents, that a lot of them felt that they simply couldn't put the kind of work into developing a policy that we were putting into it. And so we wanted to have something that was fairly generic, that people could use themselves, pick out the good things, pick out the bad things, or pick out things that they didn't think would apply to their firm. And you'll see, if you look at the material, that there are about 10 pages, the policy itself is about 10 pages, and the endnotes are about 20 pages, because we tried to give you all the arguments in favor and against of all of the things so that you wouldn't have to do all the research from scratch the way we had to do it. This has now been sent to every managing partner in every law firm in Ontario under the treasurer's signature. The intention is to review the policy after a couple years to see how it's working. We know that a number of firms have adopted it as is. The Law Society itself adopted it as is on January 24th of this year, the same day that it was approved at convocation. The Women in the Legal Profession Committee is very eager to hear from you if you have comments on how this is being applied in your firm or in other firms, or if you think there are ways that this could be done better. And the chair of that committee is now Susan Elliott, but you can write generically to the chair of the committee if you wish. But we certainly would be very interested in hearing from you, because the committee was really doing this very much in a vacuum. We canvassed law firms, and hardly any firms had a policy that we considered, how do I say this nicely, that we considered worthwhile putting the law society's imprimatur on. Some of them just said that, we have a policy of no sexual harassment, and that was it. I mean, it didn't say anything else. It wasn't publicized anywhere. The partners didn't subscribe to it. The staff, from the secretaries to the couriers to some of the lawyers, weren't even really aware of it because it was never posted anywhere or given to anybody. So we wanted something that would be more substantive than that, and that people would look at it and say, this firm does this, they have got a good policy. And then in June, just a couple months ago, Convocation unanimously approved a recommendation of the Professional Conduct Committee that there be a separate rule of professional conduct to address sexual harassment. And that too is contained in here, is Rule 27. And essentially what it says is that sexual harassment of a colleague, of staff, of clients, or of other persons in a professional context is professional misconduct. There were some who argued that it should go beyond professional context, that it should also apply that lawyers, qua lawyers, had an especial duty not to be doing anything that would be contrary to the Human Rights Code, or that would be behavior that could be seen to be sexually harassing or workplace harassing. But ultimately, I guess people felt that you can't control what lawyers do outside of the professional context and outside of the broadly defined workplace, and so it's limited to professional context. We did this because we knew that there was not just the code of conduct, but also the policy. We knew there was a problem in the workplace, and I'm sure many of you have heard that there are some firms that are known on the street, as it were, as being difficult, quote unquote, for women. And we were starting to get complaints from, and we have now received a number of complaints from articling students about the difficulty that they have had working in particular law firms. And that was why we felt that we definitely had to do something. I'm sure today you've already heard, and I've certainly seen it in here, all the statistics of the number of women employees, but also lawyers in various parts of the country who have alleged and complained that, or reported that they have been the subject of sexual harassment, including by judges. In fact, I saw in the most recent Canadian Lawyer that just came out this month, that in a study in New Brunswick, something like 31% of the women who responded to the survey said that they had received unsolicited, unwanted, sexually harassing comments from judges. And so it's certainly not just something that's related to the firm. We tried to cover the essentially 10 major points that we were told should be in every sexual harassment policy. One was just to say that there was a policy and state what the policy was, indicate who the persons were who were covered by the policy. That is a little difficult, and I should tell you, we had some real struggles with this one, because in defining the workplace, we just, we know it's not just the office. And we know that lawyers go to court, and couriers come in and talk to secretaries, and judges do various things. And so there was some concern about how far could we go in saying to a firm that they had a direct responsibility to do something for people over whom they had no control. And we were thinking, to a certain extent, of judges over whom the law firm certainly has no direct control. But we've put some stuff in the policy that I think is pretty good, indicating what kinds of things a firm should do to ensure that the people who are employed in their firm want to stay employed in their firm and feel that working in that kind of environment is a good working environment for them. And if they know that the employer is going to support them, even if they're subjected to harassment or something outside of the normally considered workplace by someone who has, over whom the firm has no control, then we think that everybody will be happier for that in the firm, and that it will reduce absenteeism and all the other things that you've probably heard about. We also wanted to outline the firm's purpose in implementing sexual harassment and to provide a definition of sexual harassment. And I think we struggled over that one for an awfully long time. And it was one of the ones where the Human Rights Commission felt that we should be talking about workplace harassment as opposed to sexual harassment. As some of you here probably already know, the government itself had started with a sexual harassment policy, and this year adopted a workplace harassment policy, so that it's harassment now on the basis of sex, but also sexual orientation, race, color, religion, the whole shebang. At that point, we decided, and we put a footnote in to let firms know that they may wish to consider doing this. We didn't do it only because by that point the Thomas hearings were right up beyond, falling over our heads, and we wanted to get this out to the firms as quickly as possible. But we do recognize that it is a deficiency in the policy if you want to have more of a workplace harassment than sexual harassment. We also indicate the responsibilities of management, the declaration of the firm to take disciplinary action, the assurances of confidentiality to the extent possible. We provide for the appointment of advisors, which some of you may or may not have in your own policies, but we had seen the government's policy and some others, and we thought that the position of advisors was actually quite a good one. This allows the complainant to actually have a first crack to talk to someone on a very confidential basis. In the government, if you complain to an advisor, that is totally confidential. Now, I should point out that in the Law Society's model, it's not necessarily totally confidential, because we felt that the responsibility of the employer in certain circumstances was going to override the complainant's desire for confidentiality, because we couldn't get the Human Rights Commission to agree that employers, if they did insist on following through with what the complainant wanted, and i.e. confidentiality, not doing anything with it, that the employer couldn't subsequently be subject to some sort of a lawsuit because the employer knew about it. Am I making myself clear? Am I too hungry? Yeah? Okay. Anyway, it's all in here. Said probably better than I am now. And we wanted to also put as much of a comprehensive procedure as possible, but we also recognize that we were talking about firms that have 2 or 3 members in their firm, to firms that have hundreds of people, and so we didn't want to limit the firm into the way in which it was going to define its own procedures and its own investigation things, and so we left that fairly general. And then we concluded with a reiteration of the firm's commitment to the objectives of the policy. So I can tell you it has been adopted in quite a number of firms, but I'm not hearing from everybody, so I don't know if some of them are adopting it holus bolus, or others are finding that it's not very helpful, and I'd certainly be interested in hearing your comments. So I think I was here to talk about the policy, and now my colleague will talk about the practice.
Well, just make some quick comments. The Law Society, I guess, in over the years has been criticized for being a follower and not a leader in a lot of areas, and I can tell you in this one that they deserve their dues, and the benchers deserve credit for getting this thing on the road, because I'm just going to briefly talk about how we dealt with it at Castles Brock, and I can say with some degree of satisfaction that it went quite smoothly through our firm, and we implemented a policy that's been in place since January 1992. And I think that the Law Society's lead and people like Denise and others' insistence on seeing this being dealt with was a major factor in firms reacting to this and the way that they did. And I think, to the profession's credit, we're off in the right direction on this one. Let me just say quickly what Castles Brock did. We, in terms of the drafting group, kept it fairly small. We had an associate, a partner, our human resources person, and our chief administrative officer. We didn't see, because we had the Law Society's policy, a lot of mileage in getting a whole group together and trying to visit every issue. I mean, the drafts are there. The other problem we had is one that Denise points out, that there was a lot of pressure to get this in place, not the least of which is that we were advising our own private clients to put policies in place, and obviously not having one up and running ourselves. So we opted for a small group. We prepared a draft. The matter was basically dealt with as a management issue. From our firm's perspective, it's an employment management issue. An employee has a right to work in a harassment-free environment, just as they have a right to work in a safe work environment for other reasons. So therefore, it was only a matter dealt with by our executive committee. The draft was dealt with, management approved, and it was adopted and circulated as a formal employment policy of the firm. And following up something that Susan Bisset said, we posted it in conspicuous places, and we ran several educational seminars. We did not make attendance mandatory, but I would say the largest majority of staff in the firm came out to the seminars. We had the human resources manager review the policies. We showed some excellent videos that were prepared by the ABA about what the issues were, and we fielded a number of questions in specific context about what we should do. I would like to think that people in our firm are aware of the policy, see it as something that is there for their assistance and ultimate protection, and we also have posted it or put it in our employee handbook, which is handed out to new employees, and I think we have to realistically see ongoing follow-up educationals and seminars to deal with it. Just quickly, some of the issues that we have had to face and are facing on an ongoing basis. We thought that the proper role or the proper persons to be involved in the advisor role, as defined in the Law Society's draft policy, is basically an administrative manager and someone from the firm's executive committee. Therefore, you have someone that the employee deals with on an ongoing basis as a manager. Plus, you have, in fact, a firm partner from the executive committee. So that's how we opted to deal with the advisor situation. In terms of the written oral type of complaint, we followed, I think, what Susan said. Not mandatory to do a written complaint, but at some point we want the complaint in writing if it's going to proceed. We opted for investigation after it got to the formal stage by a member of the firm's executive committee, obviously a lawyer. I can say that there was some discussion about whether there should be a woman involved in that investigation if the complainant was a woman. We, after some discussion, said we opted for it to remain as an executive committee person, which in our firm could be a woman. and the final jurisdiction for deciding whether a complaint had been substantiated or not proven lie with the firm's executive committee, which in our case is a 5-member elected body annually, and they also decide the appropriate discipline or sanction. We obviously reserved the person's right to go outside the firm, write in the policy if they weren't satisfied or thought it wasn't investigated properly, that a complaint could be made to the commission. And we included, I think, fairly strong language about reprisals and confidentiality, although confidentiality is a slippery slope these days, as I think Harold Rolph pointed out. And one of the things that when I was kind of writing some notes out late last night about what I might say, I mean, now that it's a rule of professional conduct, Denise, is there a whistleblowing obligation now? I mean, if I know as a member of my executive that someone, or I've concluded someone's engaged in sexual harassment, do I have to report that person to the Law Society? And second of all, what if there's some kind of undertaking of confidentiality to the complainant? I think I'll probably be calling Steve and Travis or somebody about that. I hope I won't be calling them, but somebody will be calling about that, because I think it's a tough issue. Want to just tell me what you think about that?
Well, at the moment, there is actually no whistleblowing requirement. But I know that a number of lawyers have already been calling Stephen Travis and others, a professional conduct committee, to find out about this, because they have been experiencing it either themselves or they see it happening in their firm, and the firm isn't doing anything about it. So I know that it's something that the Law Society is going to have to look at and determine what the responsibility is. What is also going to come out of this, I think, is that the discipline committee is going to have to make a determination as to whether or not certain components of evidence heard in discipline hearings can be held in camera. As it is now, it's governed by the Statutory Powers Procedures Act, and there's nothing specifically about people who have complaints such as this. But we know from our conversations with the College of Physicians and Surgeons that women are not as likely to come forward if they think that by coming forward, they're going to find themselves in a position of having a public hearing with their evidence being made public. So that's something else the Law Society is going to have to consider.
Just a couple of quick context in terms of sanctions within a law firm. Obviously, if a law firm is considering sanctioning one of its proprietors or owners, i.e. a partner, obviously one would have to look towards the partnership agreement to see which processes would have to be followed. And I suspect that if only a full partnership meeting can do a sanction, that you'd have to combine both the firm's policy and ultimately any sanction against a partner of a serious nature, such as a motion to remove them from the firm, would have to go to the full partnership. Again, one hopes that doesn't come to pass, but I think it's an issue that there are competing rights of people that you might be seeking to sanction. I guess the hard one that I haven't wrapped my mind around to a great extent, but I think it's really something that's going to come up, is the question of clients who are behaving inappropriately vis-a-vis lawyers and staff in the firm. Again, we don't have any direct jurisdiction over the client, but I guess it ultimately comes down to how strong a position one will take as to this person taking their business and going elsewhere. And I suspect that if you have a substantiated complaint, that might be one of the alternatives in terms of resolving it vis-a-vis the complainant that you'll have to undertake. But again, I think all these things, I think Harold Rolph made a very excellent presentation about how context-driven each of these situations is. And I mean, my final thoughts are prevention and education are the key. When something comes up, you have to respond and not overreact. You have to manage the problem. You have to show some sensitivity and try to resolve it. There's lots of constructive ways to resolve things without people having to leave the firm or people having to toss clients out of the firm. And I really think that it becomes just an attitudinal thing with the firm. I mean, it's going to take some time. I know that it takes time to change people's attitudes, but once the attitude is in place that this type of situation will not be tolerated, I suspect that the difficult complaints and situations to resolve would optimistically become diminished. And again, I think that as a profession, we've moved some steps forward on that, and that we'll continue to hopefully eliminate it in the foreseeable future. Those are all the comments that I have. Any questions? Yeah.
Yes, the question is whether the Law Society would await the outcome of a civil action on a sexual harassment, professional conduct, discipline hearing. Right now, that's fairly common, not with sexual harassment because we haven't had that, but it's not that uncommon to have a civil action or a criminal action going on at the same time as a discipline hearing. It really depends on the facts. If it looks like it's something that's going to take about 8 years to get through, the Law Society won't wait 8 years to proceed with the discipline hearing. On the other hand, if it looks like it's for example, in a criminal case where a person is likely to plead guilty, or there'll be a trial and be found guilty, the Law Society tends to wait for that because it'd be a lot easier. And it also depends whether there's acrimony going on between lawyers on both sides. In family disputes, we get a number of complaints about the behavior of one of the lawyers, and we tend to wait until the action is over so that it doesn't look like they're using one as a lever. So I guess it's not a very good answer. It's really ad hoc. It'll depend on the case.
Any other questions? Well, that's it. We finished 5 minutes early because Denise was hungry. And thank you all for coming.
You get 2 presents.
That's right. Oop.